Hi, welcome to our next topic in our course of Sustainable Living and Environmental Studies. Like I told you before, I'm an advocate, and during my law school days, we were taught a subject called environmental laws, in which we studied various constitutional provisions, various legislations, and various other international and national treaties developed by various organizations, developed by countries on their own, and various other municipal level or village level initiatives that were being taken place. Various roles of judiciary where the judges stepped in and furthered the cause of justice for the environment. When we began this course, I mentioned that we all are very eager to have justice for ourselves, but we also must be eager for justice for the environment. This particular topic today will be dealing with environmental laws in India. Though this is something so vast and could take as long as 6 to 10 months to teach it in proper detail, but then with the short time at hand, I have tried that we in this topic cover the basics of where in constitution we have a responsibility towards the environment, where in constitution we have certain rights towards breathing clean air and living in a clean environment, different other legal frameworks where we need to protect the environment, where we need to protect the wildlife, where we need to keep the air, soil, water clean, where we need to conserve biodiversity, and a few judgments that I have cited inside, where we can see how the courts sometimes have a tussle between industrialization and urbanization on one side and keeping sustainable environmental goals at one side. Sometimes this is a big question of conflict where development versus environment, and there you have to apply balanced approach. In this topic we shall be dealing with that. So beginning with the constitutional provisions, we're aware that the Constitution of India has certain fundamental duties. But more than that, I think we're all aware of our fundamental rights. We hardly talk about the fundamental duties. But today, let's begin with our fundamental duties. Because the purpose of this course, as I said before, is not only to be aware, but also to bring our knowledge into action. But the sad thing about fundamental duties is that we don't even know about them, let alone know about the fundamental duties for the environment. So let's cover that. Article 47 of the Constitution of India says that the state shall regard the raising of the level of nutrition and the standard of living of its people, and also the improvement of public health, which includes the protection and improvement of environment as a part of its primary duties. Now Article 47 imposes a duty on the state that it shall raise the level of nutrition and standard of living for the people. All of these mostly is also a wrong word, all of these actually are a part of the Sustainable Development Goals agenda. There's nothing new to it. If not totally coinciding, these ideas overlap. Article 48A states that the state shall endeavor to protect and improve the environment and to safeguard the forests and wildlife of the country. The fundamental duties are of the citizens, and also these articles are the duties of the state. How must a state formulate its policy? How must a state do its governance? 51AG, it's the duty of a citizen to protect. Here comes the fundamental duty. These were the principles of state policy. Just a second. So this must be a duty of the citizen to protect and improve the natural environment, including forests, lakes, rivers, wildlife, and to have compassion for living creatures, along with the right to live in a pollution free environment and utilize its natural resources, we have a responsibility to protect and preserve the natural environment. Now, under the right to life, which has been given a big broad meaning by various Supreme Court interpretations, we do know today, like all of us, even a layman is aware that he has a right to life. And that life means not just merely existing, it means living in a clean, green, sustainable environment where you have clean air to breathe, where you have good water to drink, where you have food, shelter, clothing. But with the same comes a fundamental duty of ours. We need to comply to that as well. This is the judgment. Although this judgment I will be dealing in detail in our next presentation. The Supreme Court very recently in 2024 have passed a judgment. This judgment was otherwise about a conflict between environment and development. It's a recent judgment. M.K. Ranjit Singh versus Union of India. The Supreme Court passed a judgment and reiterated that the extent of the ambit of right to equality and right to life and liberty of the fundamental right, people have the right to be free from adverse effects of climate change. Now, the court said that the right to equality and right to life and liberty incorporates that people have the right to be free from the adverse effects of climate change. And if the people of one area are being terribly suffered because of climate change, that would be against right to equality, because even they have a right to live in a healthy environment. Article 14 and 21 of the Indian Constitution guarantee fundamental rights to equality and life respectively. This is just a note that you can take. The Supreme Court in its judgment noted that the right to life under Article 21 must be interpreted progressively to include the right to a clean and healthy environment, which is essential for the enjoyment of other fundamental rights. Now, in this judgment, and in also very many previous judgments, the Supreme Court has said that right to life cannot be really enjoyed. By enjoyment, it means you cannot really live. You cannot really say that you are living. And you cannot really enjoy other fundamental rights of expression, of speech, of travel, of movement, of trade, if you are not living in a clean and healthy environment. So the Supreme Court reiterated in this judgment very recently. Other judgments are also quite old, and as early as in 19s, it was told that right to life means right to clean environment. But in this judgment very recently, it has said that it's very essential. This judgment a little more detail. M.K. Ranjit Singh versus Union of India 2024 की judgment है ये. The writ petition was presented before the Supreme Court. A writ petition means you directly approach the court, the Supreme Court. Was filed for directions to the respondents to urgently frame and implement an emergency response plan for the protection and recovery of the Great Indian Bustard. Now, what was happening that a lot of, interestingly, solar panels had to be installed. Now, where these solar panels were supposed to be installed was the habitat of the Great Indian Bustard. So, directions were made that there has to be a complete embargo. Embargo means stoppage on the sanction of the new solar projects and the renewal of the lease of the existing projects, dismantling the power lines, etc. Because they said that the habitat of Great Indian Bustard is being affected by these projects, and you need to install bird diverters so that the birds do not come into contact with those solar projects and they lose their own natural ecosystems. So the choice in this case was between promotion of solar generation and protection of an endangered species, great Indian bustard. On the face of it, both are very right causes. At one place you are saying that, okay, solar energy is very good of a renewable energy resource and you need to tap on it, and you need to make the best use of solar power. That's one renewable source of energy. It's the ultimate source of energy. The sun is always going to be there even if the waters run out, etc. So installing solar power projects is also a very good thing. This is environmental friendly. But on the contra, protection of an endangered species is also very essential. Both are very virtuous causes. So the court here was tasked to weigh and decide which thing needs to be given primacy over the others. And the court adopted a balanced approach between the conservation of endangered species and the fight against climate change, and delivered a decision based on the following conditions. These observations are very interesting. These observations are a direction in the way forward, because like we studied before, development cannot be halted to save the environment. It has to be something sustainable, it has to be something balanced. So over here the court delivered a balanced judgment, keeping in mind the following considerations: that first of all, India has committed under various international conventions, and these conventions are something where we have undertaken to stop climate change. We have done a commitment on the international forums to reduce the greenhouse emissions, to promote renewable energy. So hampering and saying a complete embargo should be there on solar power generation would be very anti international convention. So you cannot ask for a complete embargo. Secondly, the court in this said that the solar energy is a crucial step in global transition. The court reiterated promotion of solar energy is a crucial step. When we were studying about sustainable resources, so these sustainable resources have to be furthered, they have to be committed to, if we want to shift from non-renewable resources to renewable resources. The court also said, it quoted a previous judgment, few previous other judgments, where it was also held that right to healthy environment and the right to be free from adverse effects of climate change. It said that in the light of various discussions in MC Mehta versus Kamal Nath, in Karnataka Industrial Area Development Board versus Kenchappa, in Bombay Dyeing versus Bombay Environmental Action Group, the right to clean environment comes within the fine ambit of Article 21. So the court said that shifting towards climate action is important. We know that the great Indian bustard is an endangered species. So what we can do is we can tell that there has to be an installation of bird diverters, but we cannot halt the process of solar panel installation. So this was given a go, but also with certain additional things that could be done towards saving the great Indian bustard. So it has to be a holistic approach towards sustaining the existing biodiversity and also incorporating new and energy efficient techniques into the atmosphere. Coming to the law, before we go and deal with these laws, many other laws as well, let's study about a few principles or the certain what we can call Jurisprudence. Now, what is jurisprudence? Prudence, as you know, prudence means yeah, samajh, and juris means legal. So, what is the legal brain, the legal reasoning behind having any law actually? There has to be a reason why any law is made. Now, we all know about the Indian Penal Code, where all the punishments are defined, what is murder, what is theft, what is robbery, and punishments are given. The jurisprudence behind a penal code is for people to know that if they do this wrong, this is the punishment. So the jurisprudence behind few laws that the legislation has passed towards the environment, what is the jurisprudence about the same? The jurisprudence behind environmental laws are these few principles and one more, which I shall tell you about this. So the first principle is the precautionary principle. The main purpose of the precautionary principle, as the word suggests, is that the substance or activity which poses a threat to the environment is prevented from adversely affecting the environment. Like, prevention is better than cure. As simple as anything. When you know something on the face of it is going to cause adverse effects on the environment, what you have to do is stop that thing from happening. In MC Mehta versus Union of India, the famous Taj Mahal case, the Supreme Court based this judgment of MC Mehta versus Union of India 1997. This judgment was based on the principle of sustainable development, and it applied the precautionary principle. That if the tanneries, if the tanneries are causing the water to get bad, if these tanneries are releasing effluents in the water which is degrading its quality, if these water bodies are being spoiled, if the tanneries are releasing air pollution that it is causing acid rain, so all of this must be stopped. Prevention. So the precautionary principle was applied in this Taj Mahal case because it was yellowing the marble. The polluter pays principle. The polluter pays principle. The next principle talks about the absolute liability. The meaning of absolute liability means that if you have caused harm to the environment, you cannot tomorrow come and say that, oops, that was not my intention. My intention was only to, let's say, I was thinking I'll just go on a harmless spraying into the forest and just shoot blindly. And if you kill a deer, or let's say a deer or another endangered species of the forest, you cannot be like, it was not my intention, I had not intentionally gone for hunting, I was just having fun and just shooting in the air. No, you cannot take that plea tomorrow. You will be absolutely liable, which means that your intention will not matter. For harms done to the environment, if you have harmed the environment, your actions have gone beyond a certain reasonable care that you should have taken, you will be absolutely liable. And this liability will not only be to compensate the victims of the pollution but also to the cost of restoring the environmental degradation. Let's take an example that in a residential area, you install a factory of sawing wood, जहाँ पे लक्कड़ के बड़े बड़े logs आते हैं trees के, and you saw it into finer smaller pieces. Now the sawdust the sawdust is flying here and there, and the people of the residential area are coughing because that fine sawdust is entering into their windows and going into their homes and affecting their breathing patterns. So now tomorrow you will not be able to say that my intention was just to run a simple business, I did not intentionally want to harm the people. अब आपकी इंटेंशन थोड़ी ना थी कि आप ये इसलिए फैक्ट्री लगा रहे हो कि आपने लोगों की तबीयत खराब करनी है, आपकी इंटेंशन वो नहीं थी, बट people suffered, so now you will be absolutely liable. And now, because let's say there was a garden also, there was a very beautiful garden in this locality, there was a park in this locality. Now you will not only compensate the victims of this residential area, but you will also bear the cost of restoring the environmental degradation that you have done in this area. Let's say this park has suffered, let's say because of your water intensive activities. जब वो wood कटती है तो उस पर water का बहुत pressure देना पड़ता है to clean the last shavings of it. आपने ग्राउंड वाटर लेवल डिप्लीट कर दिया, लोगों के घर अब पानी गंदा आता है. So all the environmental degradation you have done, you will have to pay compensation for that also. Victims को तो आपको compensate करना ही पड़ेगा for their medical expenses, for their well-being, for tree plantation again, but you also have to pay the environmental cost of degrading this water, the degrading of this air, the degrading of the soil. These are a few laws that have been passed by the legislature based on the jurisprudence that we just studied. The third thing that another was there is public utility purpose. Nothing in the environment is your personal commodity. Everything that is there in the environment is meant for the public. It's a public good. It's a res communes. Res communes. So based on these principles are these few laws. Briefly telling, the Environmental Protection Act, as it suggests, is about protecting the environment. The Air Act is about preventing and controlling the pollution in the air. Similarly for water. Then the NGT, the statutory body that takes care of violations that are being done against the environment. The Indian Forest Act is again for the protection of forest, which is now being replaced by the Forest Conservation Act, the Wildlife Protection Act, Biological Diversity, again Protection and Preservation Act, Compulsory Afforestation Act. If you are doing deforestation, it's about the compensation that you have to pay towards afforestation. So these are laws which we can go for saving the environment. बट देन एट अ पर्सनल लेवल, अब जैसे मैंने आपको एग्जांपल दिया रेजिडेंशियल एरिया वाला कि उसने एक फैक्ट्री लगा दी रेजिडेंशियल एरिया में, तो उस रेजिडेंट्स के लोग को सफ़र करना पड़ेगा? ऑफ कोर्स नॉट. दे शुड ऑल्सो हैव अ रिकोर्स, बट विल दे गो अंडर द इन्वायरमेंट प्रोटेक्शन एक्ट? नो. Will they go under the Air Act? No. Will they go under the Water Act? No. Will they go under the Indian Forest Act? No. They can go under the Environment Protection Act because the environment is being spoiled. But better than that, the first thing that they can do, the first thing that you can do if someone around you is doing some environmental nuisance, which includes as simple as something like, let's say आपके घर के बाहर कोई कचरा फेंकता रहता है and he makes a big dump of garbage next to your residential area. Keep the residential area example in your mind. Now what you can do is, you can go to your district magistrate, you can lodge a complaint, because there is a dedicated chapter in the Code of Criminal Procedure which deals with the maintenance of public order and tranquility. And anybody who does anything which is a public nuisance, and this public nuisance could be air, noise, water pollution or unsanitary conditions, you have a recourse where you can go to the sub-divisional magistrate or the district magistrate under section 133. This magistrate can take cognizance, he can take note of your complaint, and he can issue a notice to immediately stop the nuisance. He can immediately send a notice to the person who is throwing that kachra outside your house. He can immediately send a notice to the person who is running a sawmill in your residential area. So you have laws that can protect you. You have, and this is the first remedy that you can take, because this is as simple as just lodging a complaint to mitigate public nuisance, and the district magistrate is going to help you stop that nuisance. Although this has a procedure which is present under almost 10 sections, but this is something that you can see that you have a recourse. You can go to the SDM, you can go to the DM, and you can tell them that so and so thing is causing public nuisance in my area. And for a public nuisance, it doesn't have to be a private nuisance, it has to be at a little larger scale. Then you have these laws if you see someone violating the environment, and these are the principles and other case laws. I hope this topic gave you insights about what we have as a duty towards the environment constitutionally, what recourse we have legally to save environment, to save our spaces from being created nuisance, and the ways we can take recourse to take some action. Thank you.